Insight into independent, as everyone knows, well, has passed this exam, independent directors, and also so many people are ready on the panel as independent director, but it has its own challenges. It has its own charm. It has its own responsibility. So again, the SEBI LODR Companies Act keep on increasing the importance of independent director. So it, though it is a prestige and proud to be independent director, but it takes on you, the independent director, so many responsibilities and duties that has to be taken care. So today we are with the topic and insight into an independent directors, and we have our outside panelist, Dr. Mita Dixit, Director and Family Business Advisor at Equation Advisors Private Limited. Welcome, Miss Mita. Thanks for your time. Yeah. Miss, just to formally, of course, we have Mr. Sudhakar with us and Mr. Bala. The presentation will be done by Ms. Jasveen Bindra, partner Mehta and Mehta, Aurangabad. To formally introduce Dr. Mita, Dr. Mita Dixit is a Director and Family Business Advisor at Equations Advisors Private Limited. She is an author, educator, and independent director herself. Her professional background is as a family business advisor. Ms. Mita helps founders, promoters, and business families to align their personal, business, and ownership goals. She works with business families to develop a culture of governance through family charters and constitutions. At Equations, with her team, Mita helps promoter families plan succession and ownership strategies. Mita mentors next generation successor, women entrepreneurs, and budding independent directors. She is an independent director with several listed companies. With over 24 years of experience in business growth consulting and family business advisory, Ms. Mita is a doctorate in family business management with chemical engineering background. She is a visiting faculty for family business programs, a researcher, and co-author of The 5G of Family Business, a well-acclaimed book published by Sage. Welcome, Ms. Dr. Mita. And I'll request Dr. Mita to say a few words on the topic, then Mr. Sudhakar to say a few words, and Mr. Bala for a few words, and then Ms. Jasveen, you can start the presentation. Over to Dr. Mita. Thank you.
Thank you, Dipti ji, for your wonderful introduction. And I must say that this is a very apt topic in today's corporate world, where independent directors is become a buzzword, in the sense that once upon a time when I was in my college and doing my MBA, and that time strategy was something, corporate strategy was something everybody, smallest to largest business, wanted to be into. And that was a time when our economy had opened up. So liberalization and privatization was happening. Similarly, now I'm seeing that in our country, also especially Indian corporate world, corporate governance is become extremely important, not just the word, but the concept and the practice. And that's where today, when you are hosting this webinar on insight into independent directors, I'm really pleased. I'm very happy. And thank you all for inviting me as your guest panelist. My background, of course, you have mentioned, but a few things which I would like to put it here. Indian businesses, largely, if you see, or say in any democratic country for that matter, almost 82 to 85% Indian businesses, whether they are large corporates or MSMEs, they are owned and managed by families. And this is the data which published data which we work on as a researcher. I use or work on that. Now let's talk about the corporate world. So even when I was doing my research, PhD research, I found that from top 500 listed companies, almost 369 companies had the largest share of the promoters in the companies, so equity holding of the promoters and their family members. So, families being in the business is a practice which is, I won't say centuries, but it's a millennials old practice in our country. The issue of governance and issue of or say the position of independent directors, especially when the businesses are corporate world is moving, growing, and also finding challenges of non compliance of disciplinary norms, or so financial norms especially, being an independent director and playing that role in a very ethical manner, in a focused way, and a fearless way is extremely important. So I think as we go along in our presentation and discussion, a lot of questions will come up, and I would also like to share my experiences as an independent director and as a woman independent director. So the category says so. So you do that. So we'll look forward to a very, very interesting interaction with all our participants. Thank you.
Thank you. Mr. Sudhakar.
Yeah. Good morning, everyone. Good morning, Raja sir. After a long time, I'm able to see you.
Hi.
Trust you are keeping good health.
Yes.
Participant, before I start talking about this topic of the day, that is an insight into independent directors, I want to spend 2 minutes about our webinars. In fact, yesterday and day before yesterday, myself and Atulbhai, we were at Goa for the Corporate Secretaries Conference. At this time, I have an opportunity to interact with a lot of company secretaries there. And several people came and they were talking about the webinars, what we are organizing. And I'm sure that several participants who spoke to me yesterday and day before, they were there in this program also. We were so, encouraged, and we were so delighted that because of these webinars, the participants are getting benefited. In fact, one professional asked me, sir, why you are so aggressive when you talk about the guidance notes and when you talk about the secretarial standards? So I clarified to that professional, and let me also clarify to all the participants here. To the best of my knowledge, I am not aggressive, but I am certainly assertive. What, in fact, you have to understand is, as a parent, when the children are not studying, as a parent, we reprimand them. Same is the case here also as a senior company secretary, both in experience as well as in age. My anxiety is that to say something so that it will ignite the passion in your people. That is the only reason. Otherwise, if everybody talks sweet, then according to me, then the sweetness will be more and you will have a sugar problem. So somebody has to say some harsh words. I took the responsibility of saying that, but of course, not without hurting anyone. Consciously or unconsciously, if any one of you felt that I am aggressive and I am not supposed to be like that, my apologies to you. Now, as far as the topic of the day is concerned about the independent directors, this is a topic very close to my heart because I was teaching on the independent directors in the Institute of Directors for the last almost 9-10 years. And every time whenever I teach there, when we interact with the prospective independent directors and the directors who are already on several boards, the insights what I get is really very, very, the role, the way it was getting evolved right from 2005 onwards, it's really encouraging. Because we all know that this concept of independent directors was, we have imported from Sarbanes-Oxley Act, which was the 2002. And for the first time, it was introduced in the listing regulations in 2005. And the independent directors appointment is mandated under the Companies Act 2013 also. And several company secretaries at that time were thinking that there is another opportunity for company secretaries as professionals, especially post-retirement, we can act as an independent director. I used to caution everyone that don't take independent directorship as a vocation, because the amount of arduous responsibilities and accountabilities which have been entrusted upon the directors, one has to be very, very careful. In fact, when I take IOD sessions, people used to say that, sir, you are virtually scaring us. After listening to your lecture, we can't dare to act as independent directors. That time I used to say that, no, it is not so. Whenever you take a deep dive into a swimming pool, you should know the depth of the pool. Without understanding the depth of the pool, if you are going to take a dive into the swimming pool, obviously you'll get hurt. So same is the case with independent directorship. It is not a children's play. And similarly, it is not a kind of a passive role you can play as an independent director or as a director, as a matter of fact, which was so at one point of time. Prior to especially Companies Act 2013, one could afford, and similarly prior to SEBI listing regulations 2015, one could afford. And we all know that most of the time, these retired bureaucrats and the celebrities, they used to become directors in some of the boards, and they used to enjoy the fringe benefits offered by those companies. But post these two regulations, now the amount of responsibilities which were there, in fact, qualified people also before accepting the directorship, one has to, I mean, they have to think twice about that, and they have to have a proper due diligence conducted before accepting any directorship. So another major dilemma is that how to join a company as an independent director. At the same point of time, the promoters are also into a dilemma that how to bring an unknown person who is not connected to me as an independent director on my board. So both sides, it is we have to deal with a new animal kind of concept. So today, mostly we will be focusing not on the other aspects, that we will organize another webinar at another opportune time. But today, what we are going to do is we are going to deal with the legal aspects of the appointment of independent directors, what is their role, responsibilities, accountabilities, etc., which Jasveen will update us on that. I'll give a pause here, and as we progress with this subject, then I will pitch in wherever it is so required. Bala sir, you may take up. Thank you.
Sudhakar, the participant has said that you can scold us anytime. It's not scolding because actually I and Sudhakar both were, and Sudhakar is still part of SSB and guidance note. We know that the purpose and the depth of both the subject, if that is followed, it will help a lot to the company secretary and to the corporate governance and compliance. And that will solve many issues of our professional colleagues. So we keep on, stressing to read and follow and understand that. Thank you. Over to Mr. Bala.
Thank you, Rupal. Thank you very much.
Yeah, Mr. Bala.
Good morning to all of you. I have a great pleasure in welcoming you all for Saturday morning seminar on my own behalf and also on behalf of Mehta. We heard on the panelists whatever they said. One thing I would like to definitely compliment the SSP board and ICSI, especially to bringing out the wonderful guidance note. Because probably what happens is, though guidance notes are actually published, many people, they don't go through the guidance notes. That is the fact of the life. Sudhakar has been also emphasizing in the past seminar as well. Recently, I happened to see some of the orders passed by the various adjudicating officer. There they are referring the guidance note issued by the ICICI Institute, and they are pinpointingly saying, this is what it is guidance note says, this is where the failure has taken place, this is what the non-compliance is there. They are pinpointingly, they are actually bringing out, there are elaborate speaking orders are there in these aspects. So with respect to that, so many heads putting their knowledge and ideas and other thing and all, bringing out the wonderful guidance notice to help the professional, which we should definitely make use of it. That is one thing I am also very clear on that. In fact, although I am a retired person and other thing and all, whenever any new guidance notes comes, even the invitation paper comes, consulting paper, I go through thoroughly and see what is the things, etc. and other thing, and I do that. It is a continuous process. I think either in employment or in professional, we are actually bound to do, we should do it. That is one thing. Second thing is coming to the independent director. Yes, as Sudhakar puts it, after the 2015 LODR and 2013, the responsibilities costed upon the independent director are much, much more actually. Especially it all happened after the Satyam scandal, which was named as India's Enron in the year 2009. I remember after that, the Narayan Murthy 2 committee was actually constituted especially to go into the ethical aspects of the business and also the independent director role and responsibility, because in Satyam, all the independent director will resign because of this. So because of that, that actually has come out, which ultimately culminated with the various things. And there are n number of accounting standard has been issued by ICAI. And the 2013 Act, if you all will recall it, especially section 129, section 134, which it talks about auditor responsibility, which has to be seen by the audit committee, who's consisting majority of the independent directors. This is where it actually comes when it's come to the transparency and disclosure and also timely disclosure. All the thing which has come, it has been costed very high responsibility on independent directors. Today, I know personally there are many independent directors who just joined casually without having adequate things and other things, and now they are in trouble. There are a lot of cases which are all going on against them in the judicial things, etc. and all this. So this cannot be taken as a lightly as an independent director. We need to do a lot of things. We need to do a lot of questioning as an independent director. And again, there is a lot amount of coordination need to be done in getting the papers into the company secretary, who is the pivotal person in the company. He has to ensure all the documents are actually put forward, the due process, board process is followed. All those aspects are there. The question may arise, as Dr. puts it, that most of the family-run companies are there in India. In this case, people of the promoter will say, why not independent director should align with me rather than I am aligning with the independent director, because I know how to do the business. I am actually doing a business on the sustainable basis. I am actually working on succession, because the excellent succession plan is actually seen in the family-owned company. Father to son, son to son, son to son. It's all the things. And also, although we are talking in the succession planning, NRC committee, etc., and all those things, the family members are very, very thorough in their understanding when it comes to the succession planning, who will succeed, what, etc., and other things and all. There are various aspects are there. Question may arise whether the independent director really independent or etc., whether the independent director liability arises in what circumstances. All those things will come. A lot of integrity, a lot of nitty-gritties we have to go through. It is a very, very important topic. I can see now itself about 130 participants are already there. So I'll ask Jasveen to proceed with the thing. Please put up your question on the chat box. We will take, and we will have the independent director who is there actually counseling and training, Dr. Mita, who will share her practical experiences. We will have more insight on this. Thank you. Go ahead, Jasveen.
Good morning to one and all present here, to the esteemed panelists and all the participants. A very important and integral topic, not only for company secretaries, but also for people intending to be appointed as the independent directors or serving as independent directors of the boards. So first of all, we begin with a definition of independent director under the Companies Act, Section 149, subsection 6, read with Rule 5 of the Appointment and Qualification of Directors Rules, specifies that a director other than a managing director, full-time director, or nominee director who meets with certain criteria can be appointed as an independent director and falls within the definition. So a person who in the view of the directors has integrity and requisite experience and expertise can be appointed as an independent director. However, the person should not be a promoter or related to the promoter or director of the company, its holding subsidiary or its associate company. Such a person shall not have any pecuniary relationship in respect of any transaction other than his remuneration and transactions exceeding 10%, not exceeding 10% of his income with the company, its holding subsidiary and associate, along with its promoters and directors during preceding 2 financial years and the current year for which the review is going to be done. As per Rule 5, the person shall possess appropriate skill, experience, and knowledge in the fields of law, finance, management, sales, corporate governance, and other criteria in other areas that Rule 5 specifies. Certain conditions on the relatives of the person, none of whose relatives shall hold security or interest in the company, its holding, subsidiary, or associate. However, this is subject to the fact that they can hold security or interest of a face value not exceeding 50 lakh rupees or 2% of the paid up share capital during immediately preceding 2 financial years and the current financial year. The relative shall not be indebted to the company, its holding, subsidiary, or associate, or its promoters or directors in excess of the amount of rupees 50 lakh. The relative shall not extend any guarantee or provide any security to the company, its holding, subsidiary, or associate, along with its promoter or the director of the holding company for an amount of rupees 50 lakh rupees, and an overall cap that there should be no other pecuniary relationship or transaction with the company. The Act also specifies an overall limit of 2% or more of the gross turnover or income for all these 4 categories of transactions with the relatives. A person who neither himself nor his relative holds or has held the position of a key managerial personnel or employee in the company or its holding subsidiary and associate during the 3 preceding financial years. However, if the relative is in the employment, this will not restrict the employment during 3 preceding financial years for the relative. A person who neither himself nor his relative is or has been an employee or proprietor or partner in the 3 preceding financial years of the firm of auditors or the company secretary firm or cost auditors of the company, its holding subsidiary or associate. And there is no legal or consulting, he's not been an employee of the legal or consulting firm that has had a transaction with the company, its holding subsidiary or associate, amounting to 20% or more of the gross turnover of the firm. The person along with his relative cannot hold 2% or more of the voting power in the company. Further, the criteria is that he himself, the person who is proposed to be appointed, or his relative, shall not be a CEO or director of the NGO that receives 25% or more of its receipts from the company, its holding subsidiary or associate, or the promoter or director of the company. So these are the criteria that are stated under the Companies Act as the definition. The definition uses the term of pecuniary relationship. The MCA Vidate circular dated June 9, 2014 had specified that what is not included in the term of pecuniary relationship. So in case the company carries out any transaction only in ordinary course of business and on an arm's length basis, that shall not be considered as a pecuniary relationship. Further, the receipt of remuneration by independent directors is not particularly considered as a pecuniary relationship. The definition of independent director as per the LODR regulations applicable for listed companies or proposed to be listed companies, Regulation 16(1)B provides the definition. It is quite similar to the definition under the Companies Act with certain changes. The changes have been highlighted in red for better understanding. So the LODR defines an independent director as a non-executive director other than the nominee director of the listed entity. The criteria remaining more or less the same. However, the only extension of the definition is that this also includes member of promoter group entities of the listed entity. For the relatives criteria, the Companies Act specifies a review of 2 immediately preceding financial years. However, the LODR states this criteria to be extended to 3 immediately preceding financial years of the and the current financial year for the purpose of review. So this will again extend to holding of securities or interest, being indebted towards the company, its to the listed entity, its holding subsidiary or associate or any of its promoters, extending guarantee and any other pecuniary relationship or transaction. And the overall limit for this purpose is it should not exceed 2% of the gross turnover or total income or 50 lakh rupees, whichever is lower. The criteria for the person as well as his relatives is should not be the key managerial personnel of the company itself. Further, it is also extended to company belonging to the promoter group of the listed entity. Employment should not have employment for the 3 preceding financial years in the audit firm as well as legal or consulting firm that has a transaction with the company amounting to 20% or more of the gross turnover. Must not hold along with his relative 2% or more of the voting rights. The condition for the NGO not being appointed as a CEO or director of an NGO that has 20%, 25% or more of its receipts from the company it's holding subsidiary associate as well as its promoters and directors. The additional criteria under LODR for the independent director and his relatives is they should not be any a material supplier, service provider, customer, lessor or lessee of the listed entity. Further, the LODR as an addition to an extension to the definition also provides that the age of the independent director shall not be less than 21 years. And it also provides a condition to avoid board interlock where it is stated that an independent director cannot be a non-independent director on another company or the board of which the non-independent director of the listed entity itself is an independent director to avoid avoid board interlocks per se. So any inputs on this point?
Yeah. You see that, in fact, I think almost just where you have put about 5 to 6 slides on the definition part itself. And I'm sure that with this, when you're running through the slides, it is very, very difficult to understand what exactly is the definition of independent director. But my advice to all the company secretaries is that whenever you are putting up a proposal to, or your NRC is asking you to determine the independence of a director, you have to prepare a small, what's called as a tabulation format in which you have to put all these parameters. If I am not wrong, under the Companies Act itself, the amount of the number of parameters are almost 56 to 58, if I am not wrong. So you have to see each and every aspect, you have to put it into that a separate box. Is it so? Is it so? Is it so? Like that. Unless until the answer to every parameter is yes, that person is not qualified to be appointed as an independent director. 57 parameters might be yes, but 58 parameter might be no. He cannot be appointed as independent director. This was what we struggled in 2014 when we were to appoint independent directors, because we were around that time requires about 80 to 100 people in our group when I was working with Reliance. How to bring the people, that was a real challenge at that point of time, which is going to be a challenge even in 24 also, because the people who have been appointed, they are going to complete the 2 terms of 5 years each in the year 24. So you all have to gear up now to ensure that those independent directors have been timely replaced now. For that, the exercise has to be started by now onwards. That is also one of the reasons why we have chosen the topic for today about the insight into independent directors. And in case you are listed, your company is a listed company, the what's called as the rigor is a bit more. The definition is further exhaustive, what it was already exhaustive according to me in the Companies Act. So this is one aspect one has to keep it very clearly. In case of LODR, they have also given not only other qualifications, even the age also. As far as Companies Act is concerned, of course, age is not prescribed. But that doesn't mean you will appoint a minor as a director. You can't appoint a minor as a director. We all know that, because you don't have the contractual ability or capacity to do that legally. So that's why anyway minor cannot be appointed as a director. At the most he can be a shareholder under guardianship of someone else. But as far as LODR is concerned, it has also prescribed that 21. What according to me is that neither the Companies Act nor the listing regulations, they have prescribed any qualifications or experience for appointment as independent director. With this, what happened is several small time listed companies, they appoint anybody and everybody as the independent directors. Of course, let us not discuss those aspects now. This is what I want to contribute. Yeah.
So the point in the LODR for board interlocks to avoid that was added by.
You have a slide on the interlock, or should I explain the interlock, Jasveen?
So you can explain it. I just have an interpretative letter that was issued by SEBI as regards the applicability of this.
Okay. See, interlocks means what? That some companies before the interlocking was prohibited, some companies, what they were doing is the executive directors of a company have been appointed as independent directors of the other company because they were qualified to be so under both listing as well as under the Companies Act, or the listing regulations under the Companies Act. And they were having a kind of a barter system. Those executive directors of that other company are becoming independent directors on this company. That is what is interlocking. That means you scratch my back, I will scratch yours, kind of a thing. So this is just to what's called as what's called as that camouflaging the law, or you are trying to just for a kind of an eyewash and all. That's why SEBI thought that now let us prohibit the interlocks. So if I am not wrong, somewhere I think 2018 or so, this was prohibited. You cannot have interlocking of the director. That means your executive directors or the independent directors on the other company, and their executive directors or independent directors on your company. That is precisely what interlocking is concerned. Yes, Jasveen. Yeah.
Thank you, sir. So SEBI had issued an interpretative letter in the matter of Sundaram Finance Limited. Like sir rightly said, that this amendment was introduced on May 9, 2018, which came into force on 1st October 2018. So Sundaram Finance Limited had applied to SEBI for its interpretation as to whether this amendment is applicable to the existing directors as well as new directors, or is it a prospective effect where the applicability is only for new appointments or reappointments? So SEBI through this letter had clarified that the amendment would apply to both the existing directorships as well as to new appointments and reappointments.
Again, coming to the independent director, as Sudhakar puts it very clearly, there is nowhere exactly defined what is the independent director, but there are certain criteria which have been actually mentioned. Ultimately, at the end of the day, the board takes a call and determines whether the director is independent or not. It is actually a state of mind. I remember when the independent director concept came, that time, there are a lot of soliciting firms. They were actually in the company, they are actually providing the services, and their senior partner or actually a director. The companies, as Sudhakar puts it, anybody and everybody can be appointed as an independent director. Some of the companies have actually said that we will appoint a solicitor who is actually on the board. He is not connected with the company, etc. and other things, so he will be an independent director. This was actually happening. The company where I was working, there also the position came like that. But that time the chairman categorically asked, Mala, what you are saying, either he is independent or not. As Sudhakar puts it, I had taken the criteria and gone through. When I gone through it, I found the company has been taking opinion from the firm where this senior partner is there, and he is actually on the board. I told chairman very clearly, sir, we are actually taking an opinion from their firm. So in such a sense, we cannot be an independent director. He can be a director, but he cannot be an independent director. Matter came up for discussion in the board. There were a lot of discussion took place. In fact, there are many people, many senior directors were there. No. He is still independent because, they are working the Chinese wall concept because he doesn't know what opinion you are taking. You are dealing with some other partners of the company. He is not involved in this. He is not connected. All those arguments were actually put forward and were discussed. But ultimately, the chairman took a call. Bala, what you are saying is correct. I go by that only. Whether let us do the business with him and be a director, or otherwise, if we want to become an independent director, let us stop the business with this company which is the soliciting for. That was the call which was actually taken. Ultimately, the director wanted to be an independent director because he never wanted to leave the company as such and other thing and all. Company has actually discontinued taking the opinion from that firm, and they moved away from that firm. That is why he became the independent director when this concept came for the first time. I just thought of sharing with you. Because the question is, as Sudhakar puts it very clearly, it is a great amount of the exercise needs to be done by the company secretary fulfilling, because he is really speaking a charioteer who is actually driving the board. Because the board is actually looking upon the company secretary for various advices, interpretation, laws, etc. and all these things. It is the company secretary. He has to do a lot of groundwork. He has to fulfill the compliances requirement according to me. Yeah.
Thank you, sir. So certain questions, can a friend of the director be considered as an independent director? So the law actually does not prohibit the appointment of a friend as the independent director. Can spouse of the independent director be appointed as the independent director? The answer is no, because the independent director cannot be a relative to the promoter or the director of the company it's holding subsidiary or associate. Even after specifying a number of criteria under the Companies Act as well as the LODR, what is to be considered is that independence is a state of mind. So even if the criteria are met, it is required by the independent director to have an independent judgment per se to the decisions or matter considered by the board. So any inputs?
Here I will like to say something, because this is a very crucial slide, because independence is a state of mind. Law describes so much, but still it is onus on that independent director. If that independent director do not exercise or develop the independence in his or her thinking and execution or advisory or participation, the same will hit him or her very badly in future, because the onus of duties and responsibility is there, and the same will be questioned at that time. Even though, since you are eligible as independent director by law, you are there on the board. But what is required is then use your independence. After appointed as an independent director, you should not lose your independence in your thinking, behavior, execution, and participation. That is a very crucial part. And that's why I feel this is very important, that independent director, once become independent, should always remain independent. Yeah, please.
You are right.
Any
Dipti,
panelist?
Yeah.
You are right, Dipti. Actually, the question in my mind is always there. In how many companies the independent directors are really independent?
But I
See,
would add one point here, Professor Bala, that mostly the boards or the promoters, they want correct advice and they just don't want to indulge in wrong practices. So there is, when independent director shows that independence, or say independent thinking, or difficult questions are asked, then I think the board or the executive directors, they appreciate it. At least I have seen that in most cases, when there is nothing wrong, or say there is nothing to hide from, then the promoters are absolutely open and they encourage independent directors to come out with their opinions and their frank, honest, and straightforward views on challenges. So I think it's both ways. The independent directors must maintain, and also the board must appreciate that independence of the independent director. Yeah.
See, one more thing I would like to add here legally is that most of the times what happened is we have to ensure the compliances at the time of appointment or at the time of the transaction when we are entering into. As far as the criteria for independence is concerned, that should be like 24/7. The independent director has to ensure that At all times, he should preserve his independence. Any point of time, he compromises his independence because of any reason, and he disqualifies to act as an independent director, and the company makes a fox paws on that, then they will get into a difficult situation. So it is the response. That's why, in fact, that every year the independent director has to give an affirmation that he is an independent, his independence is in state, in state completely and intact it is rather. At the same point of time, if it is a listed company, the affirmation what he has to give is, in fact, that I think 2-3 lines the listing regulations prescribes that at any point of time he has not compromised his independence, he is maintaining that blah, blah, blah and all. And in addition to that, even the board has to give the affirmation that independent director's independence is intact. So that means what the entire board also have to ensure that every independent director's independence is intact and it is not got compromised or that independent director become disqualified for any reason. So here company secretary has to play a crucial role. Merely the independent director is giving an affirmation that should not be. He has to have proper checks and balances and has to ensure that independence at all times is there. Number one. Number two, that whenever the regulator comes, it is the responsibility of the company to establish that its independent directors are qualified as per the criteria prescribed both under the Act as well as under the listing regulations. By merely saying that, no doubt about it, independence is a mindset, independence cannot be legislated, independence is a perception, independence is not a mirage, all these things are there. But at the end of the day, you have to establish legally the independence of the independent director as per the criteria prescribed legally is intact. That is what is to be established.
Here,
Yes,
one interesting question relevant to this. Does independent director owe her responsibility to shareholders or regulators, or who are the independent director's key stakeholders? Does the independent director not required to think in the interest of the company in case of any conflict? Since it is relevant, interesting point of discussion. Mr. Kumar Padmanabhan. I'll request panelists to just give answer.
Dr. Mehta, you would like to take that? Okay, I will take that for the question. See, any director, the first and foremost responsibility of the director is neither to the shareholder, nor to the regulator, but to all the stakeholders. His primary responsibility is no doubt to protect the interest of the shareholders as well as of the company. And earlier he used to have some fiduciary responsibilities and accountabilities, whereas now Companies Act 2013 has defined the duties of directors. So the director's duties to go to this extreme that even for the environment protection is also his responsibility. So that's why, whether he is responsible to the shareholders, answer is yes. Is it only to the shareholders? Answer is no. His responsibility is to the regulators? Answer is yes. Is it only to the regulators? Answer is no. So at the end of the day, if you see that independent directors' responsibilities slightly over and above the directors, every director has the more or less the same responsibility.
Thank you.
But as far as the independent director's responsibility is concerned, it is little more than the executive directors. God forbids if anything wrong happens in the company, the first and foremost persons who are, the directors who are going to be taken to task by the regulators is the independent directors. Because they are the people who are expected to ensure the checks and balances as far as the board is concerned. Because the executive directors, non-executive, non-independent directors are always gets tempted to work in a different way. They may compromise the interest of the shareholder, that means other than the promoter and major shareholders. But as far as the independent directors are concerned, it is their responsibility to ensure the compliances. That is one of the reasons why Regulation 23 has mandated that as far as the related party transactions are concerned, the independent directors who are members of the audit committee, they have to approve the related party transactions. So whenever the question of related party transactions, whenever there is a question of conflict of interest of the promoters or executive directors comes, the independent directors have to act in a more what's called as in a completely more compliant manner. In fact, Jasveen has one or two case laws also on this. When it comes, we will discuss it further.
So we can say that independent director has to take interest of the company within the parameter of the law, all the applicable law, and ensure corporate governance. And when we say the interest of the company, obviously the interest of the company, a shareholder and other stakeholder will be protected when the interest of the company itself is protected, right? Yeah.
So that's
Yes,
why
sir.
I told Dipti that when he were 166 prescribes that he has to take care of the environment also. That means what he got a responsibility towards the society also as such.
Right.
There is
Yeah,
another,
Jasveen.
there is another question.
Yeah, I know, Mr. Bala.
Yeah.
I think there are too many. As usual, we'll take at the end.
Okay.
What do you think?
Okay.
I think because this was we were talking and relevant, so I just took it. Otherwise, at the end, we'll take that will be sped up. Okay. And we'll allow at that time if that questioner want to speak also.
Okay.
Okay. Okay to all. Then we'll move. Sudhakar and Doctor.
Yeah, I'm fine with. I have any
Okay.
debate is okay.
Okay, fine. Thanks. Go ahead.
The applicability for appointment of an independent director. So the Companies Act states that the independent director should be appointed for listed public companies where they constitute 1/3 of the total number of directors on the board. For the public company having a paid up share capital of 10 crore or more, or turnover of 100 crore or more, or outstanding loans, debentures or deposits exceeding 50 crore, shall be required to have at least 2 independent directors on its board. The only exception for public companies is if they cease to fulfill the condition for 3 consecutive years, then this will become they can be exempted from it. Further, the exemption is also applicable for joint venture companies, wholly owned subsidiaries, and dormant companies. As regards the LODR requires the appointment of an independent women director, at least one independent women director for top 1,000 listed companies by April 1, 2020. So top 1,000 companies require an independent women director appointment. Where the chairman of the board is a non-executive director, 1/3 of the board shall constitute of independent directors. Where the chairman of the board is an executive director, half of the board shall be constituted by independent directors. Where the chairman is a non-executive director, however, is in some way related to the promoter or management of the company, again, half of the board shall be constituted by independent directors. Where a company has outstanding SR equity shares, special right equity shares, half of the board shall be constituted by independent directors. In case of material subsidiaries of listed entities, at least one independent director on the board of the listed entity shall be a director in the material subsidiary. For the purpose of LODR, material subsidiary means a subsidiary whose income or net worth exceeds 20% of the consolidated income or net worth of the listed entity and its subsidiary. Appointment of independent directors and committees. For the constitution of the audit committee, the Companies Act section 177 of the Companies Act states that majority of the members of the audit committee shall be independent directors, whereas the LODR states that 2/3 of the members of the audit committee must be independent directors, must be constituted by independent directors. With regard to nomination and remuneration committee, Companies Act states that half of the members shall be independent directors and the chairman of the NRC committee shall be an independent director, whereas the LODR states that 2/3 of the members of the NRC shall be independent directors and the chairman shall be an independent director. In case of stakeholders relationship committee, at least one independent director shall be a member of the stakeholders relationship committee. And as regards risk management committee, the LODR states that at least one independent director shall be a member of the risk management committee. And in case the company has SR equity shares, 2/3 of the risk management committee shall be constituted by independent directors. The Companies Act as well as the LODR states that in case a
Just
company...
1 minute, Jasveen, please
Sure.
go back to the previous slide once.
Sure, sir.
See, in case of listed companies, there is an obligation on the company to give the skill sets required by its board. What sort of skill sets the directors are expected to have, that is to be given in the annual report of the company. And in addition to that, the companies also have to map that which director is having that kind of skill sets. This is also to be published in the annual report. Why? One of the reasons for that is that if you see this, all these committees, the independent directors have to be there. So when the committee constitution is taking place, it is the responsibility of the board to ensure that the person having that particular skill set, what it is required by the committees, they have to be appointed there. Suppose if you are appointing a technocrat who has no clue about the finances and you are appointing him as a member of the audit committee, he may not be able to play a crucial role. So similarly, the person who got experience in the HR side or in the human relations or that kind of a skill sets, they have to be in the NRC committee. So risk management committee, audit committee, NRC and stakeholders, in addition to this, corporate social responsibility is also there, CSR committee. So the skill sets, when as a company secretary, when you are dividing the skill sets required by the board, please do keep these 5 committees and what kind of skill sets required to become member of this 5 committee. That is what your board is having the expert. Yes, Jasveen, go ahead.
Thank you, sir. In case the company is required to appoint higher number of independent directors, due to the composition of the audit committee, the company must appoint such higher number of members. So I'll just give an illustration for this. Let's say ABC Limited is an unlisted company having 6 directors in its audit committee. So as per the composition of the audit committee, it shall have majority of its members as independent directors. So 4 out of 6 members shall be independent directors. Now, although being an unlisted public company, the requirement is only for appointment of at least 2 independent directors. However, for the purpose of ABC Limited, the limit will get increased from 2 to 4 due to the constitution of the audit committee. The procedure for appointment of an independent...
I think you have a slide on directors to retire by rotation vis-a-vis the independent directors. Do you have that slide or you don't have the slide?
No, so it's not particularly included.
Okay.
But I will...
See, let me also take this opportunity that under section 152, the constitution of the board should be in such a way that 2/3 of the directors are to be determined to retire by rotation. That means if your board size is say 6 directors, 4 directors to be determined to retire by rotation. And out of that, every year, 1/3 of the directors have to retire by rotation. Independent directors' appointment is for a period of 5 years. That's why they are not liable to retire by rotation. So they should not be part of the 2/3 of the directors. So now what happens is when you are having a board size of say 6 directors, and if you are out of that, you are having 2 directors who are independent directors, and say 3 directors who are executive directors and not liable to retire by rotation as per your articles or as per the resolution, then what is happening is out of 6 directors, 5 directors are not liable to retire by rotation. So your board composition is not correct here. You have to ensure that you have to make your executive directors, they have to make them as liable to retire by rotation, though their appointment is for a period of 5 years as executive directors, but they can be liable to retire by rotation. Or alternately, you have to increase your board size in such a way that the other directors whom you are appointing, they are liable to retire by rotation. Please ensure that, because in the recent past, there are 1 or 2 companies which have come to my knowledge that the board composition was not according to 152.
You touched upon a very, very right point, Sudhakar. This is one dilemma I actually faced. at the particular time when I was working in the company, more or less the same situation where you actually said it here. So that particular time, after going through it, I discussed the matter with the chairman. What we done is we have actually made the executive director, that also a managing director, one of the executive director for retirement. Then immediately, Sudhakar, a very highest amount of repercussion which actually broke out. I had a very tough time with both of these directors. They got very furious on me. How can you make us to retire? We are actually at the employment. We are supposed to retire at the age of 60. That's so many things. You're done wrong. You don't know anything. What are you talking? All such things have flowed out. They even gone to the extent of taking an opinion from S.R. Shah at that particular time. All those things has happened. And ultimately, the company actually said, yes, in the situation where because what happened, two vacancies are arisen. That is why we'll have to do that. So the article has already provided very specifically, in case of falling short of the retirement by rotation, the whole-time director are supposed to retire. That provision was there. I had a very, very tough amount of time. As you rightly said here, it is the responsibility of the company secretary to put it in the correct thing, get the things done rightly. That is right. You got a very, very valid point, Sudhakar. I experienced this.
In fact, you say that people have a wrong notion. The complexity of the sections is only 186, 185, 188, and other things. It is not so. According to me, 152 is a very complicated section, and with all due regards, experienced company secretaries also make a fox pass in this kind of things. With all due regards to the company secretaries, 152 clarity, all the company secretaries, even at the senior level, are not having it. Pardon my saying that.
That is why it goes against strengthening the point what you also insisted, which I said, that we'll have to keep updating, we'll have to keep reading, we'll have to keep reading the guidance note which are published, which are actually applied by many minds.
Yeah. Jasveen, please go ahead.
The procedure for appointment of independent directors. So first, the applicability, the triggering of applicability under section 149 can be either pursuant to listing or the crossing of the threshold limits as per the last date of the latest audited financial statements. The need to appoint independent director arises immediately upon crossing of the thresholds, and there is no transition period particularly given under the Act for the appointment. Obtaining DIN, any person being appointed as the director has to obtain DIN before such appointment. Additionally, for an independent director, they have to register with the data bank maintained by IICA pursuant to section 150. And before such registration, they are required to also pass an examination for this. Recommendation.
Okay. Just wait 1 minute. Please go ahead. Please go to the previous slide.
Yes, sir.
See, as we know that a director's appointment can be prospective. That means if I am in the month of July, suppose today, I can appoint a director that effective 1st August 2023, he is appointed as an independent director. That is possible. But if that director is not having a DIN at the time of his appointment, right? You cannot say subject to his obtaining the DIN number, we are appointing him as an independent director. That is wrong. You cannot pass that kind of a resolution. The director should have a DIN number when you are appointing him as a director, whether even if it is a prospective resolution also. So the first and foremost thing as a company secretary, before even you determine the criteria of independence of a person, you have to ensure two things. Number one, whether he got the DIN number or not. Number two, whether he is exempted from the proficiency test or he has passed out the proficiency test and he got his name registered in the data bank. Okay? Yeah. Yes, just go ahead.
In fact, Sudhakar, when we appoint the director, we normally write at that particular time, along with the director, along with his DIN number as well.
Correct.
Recommendation of the NRC. So wherever the company has an NRC constituted, the NRC will be required to formulate a criteria for determining qualification, positive attributes, and independence per se of the candidate. The LODR requires formulation of a policy on the remuneration of the directors as per by the NRC, and the appointment to be carried out in that regard. The NRC shall particularly evaluate the balance of the skills, knowledge, and experience on the board and prepare the description of the role of the independent director. And on the basis of this analysis, the NRC shall recommend the appointment to the board. Thereafter, the selection process by the board, the appointment process of the independent director shall be independent of the company management. The board shall ensure that the person who's being appointed has a balance of the skills, experience, and knowledge that are required on the board. In case of reappointment of independent directors, the board shall recommend the appointment based on the recommendation of the NRC, particularly on the basis of the evaluation of the independent director that has been done. In case a person is debarred by SEBI, the board shall be conscious about the same, and that person cannot then be appointed as the independent director. For that purpose, they are also required to make a declaration in this respect that the person being appointed as the independent director has not been debarred by SEBI in the corporate announcement made. The independent director has to give its consent to act as the director under DIR 2. Further, they have to disclose their interest by inform MBP 1 for the notice of any company in which they hold directorship as well as shareholdings. They have to also submit a form of DIR 8 which specifies any previous companies in which they are appointed and disqualification under 164. And they have to also declare, a proper declaration has to be given in regard to meeting of the conditions of independence by the independent directors. The profile of the independent director has to be submitted and shall form a part of the notice as part of the explanatory statement when the resolution is put forward to the shareholders. The profile is also to be uploaded on the website of the company and to be forwarded and filed with SEBI. The requirement of approval by shareholders. So upon the consent of the board, the shareholders meeting shall be called upon. The appointment of the independent directors requires approval of the shareholders in the AGM, EGM, or by way of postal ballot. The company is to be conscious that the explanatory statement shall provide a justification for choosing the proposed person as the independent director, and a statement that in the opinion of the board, the person actually meets the criteria of independence. In case of reappointment, the performance evaluation report shall also form a part of the explanatory statement and an annexure to the notice. In case of LODR regulations, so as provided under LODR regulations, if the independent director has attained the age of 75 years, a special resolution will be required to be passed for appointment or continuation of appointment. Further, LODR also states that the approval of the shareholders for the appointment of independent director shall be taken at the next upcoming general meeting or within 3 months of the appointment by the board, whichever is earlier. Thereafter, a letter of appointment shall be issued to the independent director, which shall state the tenure, expectations, duties, code of business ethics, code on PIT regulations for listed companies, remuneration, and other details in the letter of appointment issued. Directors and Officers Insurance, Regulation 2510 of the LODR, with effect from 1st January 2022 for top 1,000 companies by market capitalization, require a Directors and Officers Insurance to be taken for all independent directors. This is also required to be taken for high-value debt-listed companies. The purpose of this insurance is to protect the independent director from legal liabilities or claims. The last step in the appointment is the entry in the statutory registers and disclosures. So for listed companies, the intimation of the appointment shall be within 24 hours of the appointment to the stock exchanges, filing of the form DIR 12 and entry into statutory registers maintained with the company. So any inputs on this?
Yeah, one more important thing when you are appointing independent director is that please be clear with him that what are the his entitlement is concerned. Because independent directors are entitled only for three things. Number one, their sitting fees for attending the board meetings and the committee meetings. So you have to clarify him how much is the sitting fees for the board and committee meetings. It may be separate or it may be the same. Second thing is that they're entitled for reimbursement of expenses for attending the board meetings. The third thing what they're entitled for is that a profit linked commission. Of course, now even the companies, they are not having the profits also. Some amount of commission you can pay as per Schedule 5, which was not there earlier. And the independent directors are to be clearly told that they are not entitled for stock options. Why I'm saying this thing is that recently one thing which has come to my, and I came across is that in one company, the independent director has been appointed. That company is having a stock option scheme. This independent director, before joining that, he noticed that this company is having a stock option scheme, and he was expecting that he will also be given the stock options. After his appointment, down the line, he asked that when I am getting my stock options, the company said you are not entitled for stock options. Then he said, this is ridiculous. I am not interested in continuing as an independent director. There is a problem has arisen there. If an independent director is resigning from the company after within 1 year of his appointment, that is going to be a major setback to the company. So certain things you have to clarify. You cannot presume that it was समझने वाली बात है. It is mentioned in the act so clearly and all. Please ensure that the directors might not be knowing the law. It is the responsibility of the company secretary to clarify certain issues. Even if he is knowing also, it is better to clarify, sir, these are the emoluments what you are entitled for. It may be there in the letter of appointment. It may not be there in the letter of appointment, that crystal clear, but you have to clarify certainly at the time of his appointment.
Here, I will say it is suggestive that better you write that what independent directors should take care. They should not have this, so that it is clearly communicated and they read that properly and they sign and get abide by that. Because that helps, as you rightly say, they are not knowing the law. They may know as a general knowledge, but not in depth. And there are so complicated requirements of an independent director. So if we reproduce for them for reading, that helps and they keep in mind. Yeah, thanks.
So case law, in the case of Majestic Auto Limited, the SEBI whole-time member passed an order. The point that was discussed over here is, can the shareholders directly by invoking section 160 go ahead and appoint an independent director? So the SEBI held that simply because the shareholders have proposed certain names to be appointed as independent director, it does not mean that they can do away with the criteria of NRC recommendation and board approval that is required prior to the appointment of the independent director. An important question that arises several times: can an independent director be, for the first term, be appointed as an additional director by the board? So to understand this holistically, we have to consider section 150, which states that the appointment of the independent director shall be approved by the company in the general meeting as per section 152. Referring to section 152, it states that save is otherwise provided, every director shall be appointed in the general meeting of the company. The exception wherein the term save is otherwise provided refers and takes us to section 161, where the board of directors have been given the power to appoint additional director. Now, on reading all these provisions harmoniously, the Act actually confers a power on the board to appoint additional director designated as an independent director, subject to the approval of the shareholders. Further, Schedule 4 also provides that the appointment of independent directors should be approved by shareholders. However, this does not imply that this approval is a prior approval. Therefore, the board can go ahead and appoint it, and later on the shareholders' approval can be taken for the same. for calculating the tenure, the date of the board resolution shall be considered as the effective date. And for the purpose of listed entities, the appointment of the independent director shall be by way of the special resolution, and the approval of the shareholders shall be obtained within 3 months or on the date of the next general meeting, whichever is earlier. So, any inputs on this?
Yeah, you also put the second term also, then I will explain this.
Sure. I'll be taking the second term in the tenure, sir. After that, I will be taking.
Yeah, correct.
Whether the resolution by circulation is appointed for can be allowed for the appointment of the independent director. So the Act per se does not have any restriction on appointment of independent directors by way of a resolution by circulation. However, it is important to ensure that the NRC has duly discussed and recommended the candidate before the circulation of board resolution to the board of directors. As a part of good corporate governance, it is always recommended that the independent director is appointed in a duly convened board meeting so that effective discussion can be carried out on that. Can the appointment of the independent director be done to fill casual vacancy by way of resignation of another independent director? So in case of resignation, a new independent director can be appointed either as an additional director under 161 subsection 1 or pursuant to the casual vacancy under 161 subsection 4. If the appointment is pursuant to 161 subsection 4, the term shall be the balance tenure that was left of the original independent director. So the term would be less than 5 years in this case. In case of the listed entity, the LODR regulations provides that the vacancy of the independent director is required to be filled not later than 3 months from the date of the vacancy, casual vacancy, right? Whether the independent director who is proposed to be reappointed on the board shall give a fresh consent or disclosure of interest. Whenever the tenure of the independent director ends upon the conclusion of the first term, reappointment would be treated actually as a fresh appointment, and all the compliances regarding consent, disclosure, etc. need to be complied again. I will be taking up reappointment in great detail when the tenure of the independent director is discussed. So the tenure of the independent director. The provisions related to the tenure are section 169, subsection 10 and subsection 11. So subsection 10 says independent directors can hold office for a term of 5 consecutive years and thereafter is eligible for reappointment on passing a special resolution. Since the term used is up to 5 years, the tenure can even be shorter than 5 years as may be determined by the board. However, whatever tenure, say suppose if the board decides that the tenure would be of 3 years, that would actually be treated as a one proper term of the independent director. Moving on to section 149, subsection 11. No independent director shall hold office for more than 2 consecutive terms. Any person after the completion of these 2 consecutive terms can be eligible for appointment after a cooling off period of 3 years. However, the independent director should not be associated in any position of the company during these during the cooling off period. As per regulation 25(2) of the LODR regulations, the maximum tenure is as per the Companies Act. However, the appointment shall be subject to special resolution passed by the shareholders.
Yeah, just when you give a pause here, I will explain. You then go back to the previous slide.
Yes.
Yeah. So, as Jasveen has explained that the independent directors can be appointed for 2 consecutive terms of 5 years each. When they have to be appointed, you have to comply with section 150, 152, as well as 149(10). If you cohesively read all the things, the board has right to appoint the independent director. Of course, subject to the approval of the shareholders subsequently. So that time, first appointment is not a prior approval. Because of that, now the question is the additional director when the board is appointing, Can they appoint him by way of a circular resolution? Answer is yes, because additional directors can be appointed by way of a circular resolution. Only the director, when he is appointed in the casual vacancy, that appointment cannot be by circular resolution. That should be done at a properly held board meeting. Number one. Number two, that because as Jasveen rightly mentioned, that up to a term of five consecutive years. Because of the word up to, that means it can be 5 years or it can be less than 5 years also. For whatever the reasons, if you are appointing the independent director for 1 year, 2 years, 3 years, whatever it is, that means the remaining, whatever the 5 minus that period for which you have appointed him, that independent director is losing its entitlement, you can say, in one way. He could have been appointed for a period of 5 years, but you have appointed him for only a period of 3 years. Means in the first term, he is losing 2 years and the company is also not able to do it. In fact, initially, some people used to think that, okay, to test the independent director, how he acts and all those things, they used to appoint him for 1 year or 2 years, and without understanding the repercussions of that. Now, the second question comes in under 149.11. Sorry, the 149.10 itself, that he is eligible to appoint for a second term of 5 years on passing a special resolution by the shareholders. So if you read the words carefully, the entitlement for the second term of 5 years comes only on passing the special resolution by the shareholders. Means what? That power the board is not having. Board cannot appoint the director, the independent director, for the second term. Like an additional director, he cannot do it. What one has to understand very carefully here is that it is a consecutive term. 2 consecutive terms of 5 years each means there should not be any break in between the terms. Before the first term gets expired, he should have the shareholders' approval in place for the second term. For whatever the reasons it is, several times it happened that the company secretaries made a fox pass and the independent director has completed his first term and the shareholders' approval is not taken for the second term. And what the board did was, the board appointed him again for the second term subject to the approval of shareholders. That is wrong. That is non-compliance. Because board has no power to appoint him for the second term. It is only the shareholders who have that. So what, as a company secretary, your responsibility is, say, for example, if any of your independent directors' tenure is getting expired in the month of January 15th, 2024, please ensure that his second term appointment is taken in this annual general meeting, which you are going to hold before 30th of September 2023. You have to say that his term is getting expired effective 15th January 2024, and he is reappointed for another period of 5 years, effective 26th January 2024. That's how you have to pass that resolution also. And when you are passing the resolution, as far as other things are concerned, like your NRC committee's recommendation should be there. If there is, you are mentioning any kind of a financial compensation to the independent directors. Say, for example, that Schedule 5 permits you to pay the commission to him a fixed amount, despite the fact there are no adequate profits. That point of time, the independent director is a related party, and 177 also gets triggered. You have to have prior approval of the audit committee also. So you have to also have the approval as well as recommendation of the audit committee for his appointment to the board. After these two, the board has to pass a resolution that for his second term appointment, subject to the approval of the shareholders. And I'm reiterating that this approval should be in place before there is before his first term gets expired. Otherwise, what will happen? Now, what are the consequences of that? Please go through the guidance note on independent directors. This particular aspect, what I'm trying to explain here, it is very exhaustively given there, because when we were revising this guidance note, we had elaborate discussions. So, based on that, ultimately the conclusion what we have come to is that before this first term gets expired, the second term approval should be in place. Now, for example, the first term got expired and the second term approval is not in place. What will happen to that independent director? Can he be appointed for second term? Answer is no, because both don't have the power. So this gentleman cannot be appointed again as an independent director. There should be a cooling period of 3 years. And after 3 years only, he can be considered for appointment as an independent director. Because unfortunately, that appointment has not been, second term appointment has not been made as per the law. Because of that, he is not eligible to be appointed for his second term. I'm sure that you all have got the clarity about this. Further, if you require that, please go through the guidance note wherein we have explained this in a great detail. Yes, Jasveen.
The very same question had been taken up that when should the reappointment be done? So
Sorry. 1 minute.
Yes.
Before that, let me please go back once again. Now about this regulation 25(2), it talks about appointment, reappointment, and even removal also is subject to a special resolution. If you remember, this earlier up to 2018, I think, if I am not wrong, this amendment has also come. As far as the removal also has been added for special resolution. Earlier, it was only ordinary resolution. For second term appointment, a special resolution is required. But an independent director who has been appointed for the second term, he could have been removed by way of an ordinary resolution. Normally, you know that whenever the appointment takes place on the higher level, a lower level removal cannot happen. That means if the board appoints a person, managing director cannot remove him. If managing director appoints a person, the HR manager cannot remove him. So same is the case here also. When you are appointing a person, it is special resolution is required. But for removal, ordinary resolution is required. This fox pass was noticed in Tata Mistry case where Mr. Nasli Wadia has been removed by way of an ordinary resolution. That time he was having the second term was continuing. He was appointed by way of a special resolution. Then this was noticed and this particular what's called as, you may call it as a lacuna or you may call it as a slip up or whatever it is, it has been removed. And it has been now even removal of an independent director is also to be by way of a special resolution only.
I think I'll just Jasbhai Trivedi welcome here. He is a company secretary and very old friend of JESCO, Great Eastern Shipping Company. He has raised the hand. Jasbhai, you want to say something? Sadam, allow him. Unmute. Jasbhai.
Yeah. Can you hear me?
Yeah, very much.
Yeah.
Okay. Mr. Sudhakar, I noted your very clear points on the subject issue. Practically, when you say that independent directors should be told about things what they are eligible for, not eligible for, in practical situations, I have seen in various other companies, not in Great Eastern, that the company secretary may not even be aware till the last moment that who is the independent, who is the director who is going to be appointed. And then that becomes a difficult situation of a corporate company secretary. So things in theory are one very nice to talk about theory and things of that kind. But practically, you have to understand how a corporate company secretary has to deal with it. He's one, insecure about his job. Second, there are various things surrounding the circumstances which can create, but that's only one part of it. If he cannot handle that, then he should not be a company secretary of the company. I agree with on that concept, because corporate governance is one thing. The major issue today that corporates face, and major corporates including HDFC's face, that Mr. Bansi Mehta's appointment was also put at stake. A person of the caliber of Mr. Bansi Mehta was about to lose except for a few votes just because of the extra regulatory authority, that is the proxy advisory, who are going beyond SEBI and MCA. What rights do they have? And unfortunately, the what do you call the PFIs, the mutual funds, have an internal policy that whatever proxy advisory says, we have to follow that, and we don't have to apply our own mind. We had taken up this issue, myself and my MD, we had taken up this issue with Mr. Injete Srinivasan, who was the Secretary MCA at one point of time, and he said that please let us know what kind of curbs that we can put on them. The issue is that today, just because there is a freedom of speech, everyone can talk rubbish and nonsense about things what they think, and because of that there are certain people who are going about and taking calls on the basis of people who have no actual authority.
Okay,
So
Jasveen, to answer
where is the law? Where is the law?
No, 1 minute. Let us, this particular webinar, we are discussing about the legal provisions. As far as the proxy advisories, their role, their responsibilities and other things are concerned, it is a debatable issue.
No, sir, 1 minute.
1 minute, let me complete. Once we start a debate and discussion on the proxy advisory role, then this webinar, we will not be able to conclude it today.
I appreciate, sir. What I'm trying to say, the legal provisions which we are discussing right now for the benefit of the members who are attending this webinar also have to understand that apart from this LODR and MCA, there is also a proxy advisory guidelines which company secretaries need to read before you select a independent director. So my only submission is this, that we will discuss that. I agree with you that what authority they have, that's a different situation. But apart from LODR and MCA regulations and the what you call the rules followed thereafter, one company secretary has to also go through the guidelines prescribed by the proxy advisories, and only after complying with all these things, appoint an independent director who will what you call pass the test of all these three things. That is my submission. I am not saying that what authority they have, that was just my outburst, but the subject is that here proxy advisories guidelines also needs to be taken care of, because at every AGM one has an anxious time whether my resolution will get passed or not. And big corporates, big independent directors names, we cannot put it in a situation where if they fail, it's a big thing. We cannot go along with that. So therefore, all company secretaries should also go through those proxy advisory guidelines before making an appointment of a company of independent director. That's it. I respect your view, saying that this will go beyond that. But the third provision which should be added is that please read the proxy advisory guidelines and then proceed. Companies Act says one woman director. Last year, proxy advisory said...
Yes, by 1 minute again. See, if you are continuing like this, again, that because of the time constraint...
No, fine. I'll stop here.
Please make a pause with all due regards.
No, definitely. So, Jasveen, you can go ahead with it now. I'm just only telling that the proxy advisory guidelines also needs to be looked into before appointment of an independent director. That's the only point.
Thank you very much for your observation. That my request to everyone is that we will open for the participants to speak only at the end of the program, not in between the program, for two reasons. Number one, this is what is going to happen if we allow the participants, because this will happen like a debate. So we will not be able to afford to have a debate at this point of time. And my request to all the participants also is, whenever we open and allow the participants to speak, please be precise. And there is no point of making general observation in webinars like this, number one. Number two, if you kindly go through the guidance note, this particular aspect has been very well covered about the proxy advisory guidelines are to be also taken.
Yeah.
So this is already there because see, as a person who got the privilege to be a part of that guidance note when we were drafting it, this issue has come up. And at a great length, we have discussed about the role of proxy advisories and all those things. And to a large extent, also our opinion is proxy advisories are not going beyond their what's called as their whatever the powers are about that this thing framework, whatever they have. They also raising certain issues. So one has to be very careful about, as you rightly said, just go through their guidelines and also see whether you are, suppose, for example, if your directors are not attending 75% of the board meetings, they will advise against that particular appointment. So these guidelines are there. Having said that, as far as the legality is concerned, now you said that the company secretary is not aware of the name of the person who is to be appointed for the second term. And the company secretary could not take up that resolution. And you also mentioned that company secretary is not having that kind of power, blah, 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 and all. But as far as law is concerned, it is law. Practical difficulties will not come on the way. You may be having any practical difficulties. It is the management's inefficiency for whatever the reason it is, not able to identify the independent director for a second term as per law. And then they have to face the consequences. So it is the responsibility of the company secretary to be able to go to the management, persuade them, explain to them what are the consequences of their inaction. And I don't know where is the question of coming that removal of an independent, that company secretary or his job security and all. Acting as a company secretary of a listed company, fairly, he must be having good amount of experience in the profession. He should not worry as far as his legal compliances are concerned. He should be bold enough to go and explain to his management. That's it. Anyway, having said that, let us leave it this discussion as far as the proxy advisory's role is concerned, and then we will move ahead. At the end of that, this thing, we can debate it. Whatever the time participants wants to spend, we are open for that. Yes, Jasveen, please go ahead.
So Sudhakar ji, I think probably the point is well taken. We can have a separate session on this, proxy regulation, because
yeah, that's what I told you, Atul bhai. The thing is like this. Today we are discussing only the legalities. Now, what is independence? What kind of a role independent director have to play? What are the challenges the independent directors face? What are the challenges the promoters face? Similarly, while you are accepting an independent directorship, what kind of due diligence you have to make? All these things, these are all general, but very important. We will discuss all these issues in another webinar. Let us confine today's webinar only to the legal aspects because this is more important also. Okay. And that time we will again request Dr. Mita to please join us. Madam, you may not be able to express much today because we are more into the legalities. Second webinar, when we are organizing you, we will again take your time in advance and we will organize that webinar. At that point of time, you will be able to play a major role. Unfortunately, today I am taking out your this thing. I'm not giving you.
It's absolutely fine. At the end, when we have question answers, I think I'll have some things to do. But legal issues, let's understand them as quick as possible.
Sure, ma'am. Sure.
Always
Thank you very
running
much.
fast. So, yeah.
Yes, ma'am. Yeah. Yes, Jasveen, please go ahead.
Yes. So just to reiterate the point of when should the reappointment be done, like sir said.
Yeah, you can push. You can skip the slide. I have already explained this. Skip it.
So is DIR 12 required to be filed for the second term? If the second term starts immediately after the end of the first term, the answer to that is that it is not necessary since there is no particularly change in the designation of the independent director. Remuneration of the independent director. Independent director is disallowed from exercising or being entitled to any stock options. Remuneration shall be in terms of sitting fees for participation in the board or any other committee meetings. Profit-related commission may be paid within permissible limits subject to the provisions under Section 197 and subject to the approval of the shareholders. Regulation 17.6 of LODR states that the board of directors shall recommend all the fees, and it shall require a specific approval from the shareholders. Approval not required for sitting fees if that is within the limits for a listed company. Independent director is also entitled to reimbursement of the actual expenses incurred, like Sir had stated, related to travel or any other. Who shall determine the quantum of the sitting fees? So the sitting fees shall be determined by the board of directors. However, it shall not exceed 1 lakh rupees per meeting, and the payment of the same shall be on the discretion of the board of directors. Can the sitting fees be paid for attending the AGM? This is a question that is asked repeatedly. So due to the use of the words or any other purpose whatsoever may be decided by the board under section 197 subsection 5, the company can pay fees for any other meetings other than board or committee meetings as well to the independent director. However, this will be subject to the determination by the board and subject to the articles of the company. Separate meeting of the independent.
Just wait 1 minute, just for the previous slide, please.
Yes.
See, this question has come up, can sitting fee paid for attending AGM? When the revised guidance note was given to for the public comments, that point of time, 2-3 people have raised this question that, can the sitting fee be paid for attending AGM? So this particular thing, again, the same thing that as we have mentioned it, due to the usage of words or any other purpose whatsoever, as may be decided by the board in section 197(5), the company may pay fees or for any other meeting other than the board and committee meetings. So to look at it in one way, if the board decides, subject to the approval of shareholders, they can pay the sitting fees for the directors attending the AGM also. But when the shareholders are also attending the meeting and the directors are attending the meeting, how can the directors be paid? And there is a governance issue maybe there. Legally, there is no problem. Yeah.
Thank you, sir.
Yes, this. Yeah.
Separate meeting of independent directors. So Schedule 4 requires the conduct of at least one separate meeting of independent directors in a financial year, wherein the other directors are not present. All independent directors shall strive to attend this particular meeting. And the agenda for this meeting is to review the performance of the non-independent directors and the board in general, review the performance of the chairman of the company, and to assess the quality and quantity and timeliness of flow of information between the management and the board, as well as the independent directors, to ensure that effective decision making is being carried out in the company. Secretarial Standard 1 is not particularly applicable to this particular meeting. Records of the proceedings may be kept, however, there is no particular legal requirement for the same. The company secretary may assist in conducting the meeting, subject to if the independent directors require the same. The independent director may also invite the managing director or any other director or experts to this meeting if they require specific clarifications in regard to that. The meeting of independent directors can be conducted through video conferencing, and a summary note of the outcome may be maintained. If the independent director decide on certain criteria or points, they may forward it or place it before the board.
Just wait, let me add a few things for the independent directors meeting.
There is a request by some participant that your view on separate meeting, whether company secretary need to attend the meeting, how about notice of such meeting, what if independent director decide to meet without knowledge of CS and minutes are circulated to CS, your views.
Yeah, so independent directors meeting is mandated as per Schedule 4 of the Act. No other section is prescribing that meeting. Only Schedule 4 is mandating that this meeting is to be organized by the independent directors, and no non-executive, non-independent director or executive directors can attend this meeting. This is exclusively an independent directors meeting only. Because of that, No sections of the Companies Act are applicable to this meeting. Even SS1 is also not applicable. Several times the questions have come in the initial years, that is when this 14, 15 years, that point of time, these questions used to be asked. Whether a notice is to be given for the independent directors meeting, whether agenda is to be given for the independent directors meeting. The answer to that was, if you don't have a notice, how the independent directors will come, where the meeting is going to be, and when the meeting is going to be, and why the meeting is going to be. So you have to give a notice, if not in a very formal way, at least an informal way. Notice need not be always in writing as far as the independent directors meeting is concerned, but certainly you have to follow the established protocols for a meeting. Even in the housing societies also, for society meeting, you call you give a notice in writing. Even for study circle committee meetings of the institute also, we give notice in writing. So that is as far as notice is concerned. Now, agenda is concerned. Do you have to give an agenda? If the agenda is not there, how the independent directors will come for the meeting? What for the meeting is being convened? So if not in a proper, the way we draft the agenda for board and committee meetings, at least the bullet points are to be there. What is the agenda is going to be like? Third, whether the minutes of the meeting are to be maintained or not to be maintained. Again, it is not mandatory. But when you have that kind of serious discussions by the independent directors, don't we think that we have to have something in writing for the future reference? So minutes are advisable to be maintained, if not in the minute form, at least in some bullet form, what exactly in that particular meeting was discussed. Now, who will maintain the meeting? Whether that minutes are to be circulated to all the entire board or not? Answer is no, the minutes need not be circulated to the entire board. But governance point of view, even the executive director should know what are the concerns of the independent directors. So if not everything, at least that whatever the executive directors are supposed to know, those are to be also informed about it. What are the concerns of the independent directors? And who will maintain the independent director that meeting minutes? Normally, it is the lead independent director who takes care of the initiative to organize such meetings, or any senior independent director. If not the lead independent director, maybe a senior director who will be chairing that session. He will give the minutes to the chairman, and obviously the company secretary is the custodian of all the secretarial records, including these minutes also. Another question comes is, can you pay the sitting fees for this meeting? As I told you that 197.5, you can pay the sitting fees for any other meetings other than the board and committee meetings. By complying with the procedure of 197.5, you can pay sitting fees for the independent directors meetings also. Can the company secretary or any other senior functionaries can attend such meetings? It is the prerogative of the independent directors. They can invite any senior official of the company, or they can ask the company secretary to facilitate the meeting. And as and when they feel like that they are going to discuss something confidential or something sensitive, that point of time, they can ask the company secretary as well as any other senior functionaries who are there to excuse themselves. This is precisely as far as the independent directors meetings are concerned. Yes, Jasveen.
Thank you, sir. Thank you for the input. Performance evaluation for independent directors. Schedule 4 again of the Act states that the performance evaluation for independent director shall be done by the entire board of directors, excluding the director who is being evaluated. The LODR regulation states that the performance evaluation shall include performance of the director as well as in regards to fulfillment of the independence criteria. The decision to extend or continue the tenure of the independent director shall be based on the performance evaluation and the report made thereto, and this has to be an annual exercise.
So I have one query here. If we go back very quickly, Sudhakar, if you can just highlight. I've seen that the performance evaluation of ID or even executive directors, that have entire exercise that happens, and different companies have got different performance parameters. Now, are there any specific parameters laid by SEBI that you have to do this independent or say evaluation only on this particular formats? Because I see the companies change their formats, their questions also change. At times, they are absolutely non-relevant questions also in this performance evaluation aspect. So, are there any norms or are there any structured way that the companies have to evaluate performance, or when the board has to evaluate performance?
No, Dr. Mita, we don't have any such kind of prescribed formats or questionnaires prescribed by neither under the Companies Act nor under the listing regulations. Let me also say that listing regulation doesn't mandate board evaluation as such. That is mandated by the Companies Act only. Number two, that in fact, in the initial year that at 2015, when for the first time we were to evaluate the boards, the independent directors were quite apprehensive about the this thing, how to evaluate the board and how to evaluate the chairman. It is the independent directors who have to evaluate the chairman. Even in our company also, the question has come, "Arey, Mukesh bhai ko hum thodi evaluate kar sakta hai." Like that it was. Then we want to explain to them that it is a part of the act. And second thing, this is not the thing, the concept is not new. It was already prevailing in the Western countries. So what happened was that now what the act says today, either the board can do it, this evaluation is concerned, or the NRC can also take up that job. Of course, they can also take the consultants outside and they can do the evaluation exercise. As far as the questionnaires are concerned, it is developed by internally. In fact, according to me, it is a good thing that the regulator have not got tempted to prescribe a format or indicative format even, because every company has its own nuances of evaluation of the directors. Right. So it is up to the company to arrive at a format, and the independent directors with their experience in other boards, they may suggest something to the company secretary, or the company secretary with his acquaintances, he can also get some other companies secretaries, how they are using the formats and all. This is how normally it is developed. Because already we are into the 7th or 8th year of board evaluations. I think more or less now we are well in place and we got that maturity of mind how to evaluate the directors, because in the first year, everybody got scored 100% marks. Every director, every independent executive director, every committee, every board, 100% marks. That means what? There are two things are there. Everybody is just superhuman beings like, or alternately, they have no idea about how to evaluate.
How to evaluate, yeah.
But now, of course, that's what I have said, that we have evolved a lot as far as the evaluation of independent directors are concerned. We got that maturity. Now, actually, the evaluation goes between the 85 to 90% of the marks. They never cross even 90% of the marks. This is what my experience is concerned.
Great, thank you.
Thank you,
Even coming to UK, most of the companies, especially the listed companies, what they do is they take the help of the outside expert. And the Governance Institute is one which actually came out for the evaluation process. They have the laid down thing, but again, it is not in the standard format or something like that. What they do is they actually go to the company, they check with them, they take inputs from the company, and then they specifically make a questionnaire which suits to each of the company what they take, they do it actually. Because I keep seeing the reports which are actually coming from the UK Institute, which they keep publishing it. So even in overseas, according to UK is also concerned, I don't think there is any format is there. Same will be the case others also, because it is varying from the company to company. It also varies from business to business. So they are not to evaluate their own methodology. Even if they take experts also, expert also cannot assess. Expert also take the necessary input from the people inside. Only thing is they can assist in doing the evaluation.
Thank you, sir. Resignation or removal of independent directors. As regards resignation, in case of the resignation of an independent director of a listed entity, the disclosure shall be made to the stock exchange within 7 days from the date of the resignation. And this shall include the letter of resignation along with detailed reasons that resulted in the resignation, names of the listed entity in which the director holds directorship, confirmation that there is no other material reason for the said resignation, And this is also to be furnished to the company, by the company to the stock exchanges. The corporate governance report of the listed entity shall disclose detailed reasons for the resignation of the independent director. Further, after the resignation, the independent director shall not be appointed as an executive or whole-time director on the board unless the period of 1 year has lapsed from such resignation. Removal under the Companies Act. The removal under the Companies Act of the independent director shall be by way of an ordinary resolution. And in case of reappointment, the removal shall be by way of a special resolution. Since the appointment happens pursuant to, the reappointment happens by way of a special resolution. However, as per the LODR, like Sudhakar sir has already pointed, the removal shall be only by way of a special resolution. Roles, duties, and liabilities of the independent director.
Queen, how many slides left?
Ma'am, I think I have around 7 more slides left.
We have to speed up because it's near 1. Huh?
Yes.
And we have questions also. The participant has started asking timeline. Okay?
Sure,
Yeah.
sure. Roles and functions of the independent director. The most important role is they should have an independent judgment on the board deliberations. They should exercise an objective view in evaluating the performance of the board, scrutinize the performance of the management from all aspects and the effectiveness of decision making, ensure the integrity of financial information and any other information for that matter, safeguard the interest of all stakeholders of the company, balance conflicting interest of each stakeholders. If there is conflict in the opinion of the management and the shareholders, the independent director is also sometimes required to moderate and arbitrate that conflict in the interest of the company. Keep a tab on the appointment, removal, and remuneration of directors, particularly by way of their exercise or function in the NRC committee. Duties of the independent director, they shall undertake induction and update their skills regularly on the basis of the requirement of the particular company. Appropriate clarification shall be requested to by the independent directors from the management or any other relevant person wherever required. They shall strive to attend all board meetings and committee meetings as well as the general meeting. This also becomes an important point for evaluation by proxy advisors. They shall participate constructively and actively in the meetings that they are attending. They shall ensure that their concerns are addressed to by the board and the same is recorded in the minutes of the meetings. They shall keep themselves informed about the company functions, activities on a regular basis. They shall not be unfair or object to the participation or the functioning of the board where the smooth functioning is going on. So they should not be unfair in the objection raised. They shall pay attention and ensure deliberations before approving the related party transactions, since that becomes a very sensitive matter. Ensure adequate and functional vigil mechanism as well as to protect the whistleblowers wherever the scenario arises. Report concerns about unethical behavior, actual or any suspected fraud, and they should not disclose confidential information, or when in possession of UPSI, they should not trade on the basis of that. Role during the meetings, since this becomes an important part of the exercise of the independent director, there are certain rules during, prior, during, and after the meeting that the independent director has to ensure. So before the meeting, the independent director shall engage with the management or the company secretary or any other person for the agenda and also suggest the agenda items for the meeting. They shall ask for appropriate information and documents for their satisfaction so that an informed decision or view can be taken. They shall thoroughly read the agenda and the supporting documents before they come for the meeting. Engage with the management, company secretary, auditors wherever required before the board meeting or any other committee meeting. They shall ensure that they adequately plan and time and dedicate enough time for the meeting, and they must avoid overboarding. Role during the meeting. The independent director at the meeting shall not hesitate to ask probing questions to the management. Deal with transactions objectively without any bias involved. Give board adequate time to revert back or get back where the information is not sufficient, so that the informed decision can be taken during or even after the meeting. Insist to record their views in the minutes of the meeting. Can maintain notes of the meeting wherever required for future reference for his own purpose. Strive to attend all meetings, board meetings as well as committee meetings. Post-meeting, they shall review the minutes carefully and ensure that it reflects the actual discussions and deliberations that happened during the meeting, and shall keep a track on the action points that are emanating from the minutes. The liabilities of the independent director, section 149 subsection 12 points out the liability of the independent director for the acts of omission or commission. It states that it shall be limited only where the omission or commission have been occurred with the knowledge attributable to board processes of the independent director and with the particular consent or connivance of the independent director. Also, in cases where the independent director has not acted diligently, he will be held liable, he or she will be held liable for the particular omission or commission by the company. Similarly, Regulation 25(5) of the LODR regulation states that the acts of omission and commission occurred with the knowledge of the independent director or with the consent or connivance, or where he has not acted diligently as per the regulations, only then he will be, the independent director will be held liable. The important question is how what falls within the ambit of knowledge arising through board processes. So this means that from any proceedings of the board or through participation in the board meetings or committee meetings, if the fact of the omission or commission could come to the knowledge of the independent directors, that would be included in the ambit. So any knowledge coming from any external source would not be covered. Certain case laws in Taneja Aerospace, this is a SEBI judgment wherein the independent director was absent from all the meetings which were particularly to discuss a particular matter, and there was a non-compliance as well as a grave commission of fraud in that matter. So in this case, pursuant to section 149 subsection 12, the adjudicating officer held that the benefit of doubt can be given to the independent director since he was not particularly present at those meetings and the fact did not come to his notice. In Islog Systems Limited, this is a SEBI full-time member order wherein it was said that the independent director did not confer with the decision of the management and ensured that the point raised was actually recorded in the minutes, and also resigned from the company pursuant to the particular act of omission. So in case of non-compliance, the whole-time member held that the independent director per se is not involved in the day-to-day management and he has discharged his responsibility by objecting to the decision taken by the board. So no action was taken against the independent director. The third judgment is in the case of KR Sasi Prabhu in the matter of SpiceJet Limited. This was a SEBI adjudicating officer, adjudicating the AO order, wherein this is in particularly with the possession of UPSI and acting upon it. So SEBI said that there is requirement of specific evidence to be showed that there has been a communication of UPSI to the independent director who has been alleged of insider trading based on such UPSI. The general test for the PIT regulations and the charge by SEBI is preponderance of probabilities. That is, even if there is a vague evidence in that respect, the SEBI can take action. However, in case of independent director, there is a requirement of a material evidence that needs to be looked into just due to the section 149 subsection 12. The classic dilemma of an independent director that every independent director faces is their appointment, remuneration, and reappointment requires the approval of the board, and their duty involves actually exercising an independent view and also objecting to the decisions of the board if they are not in the interest of the stakeholders of the company. So, which is why independent directors always walk on a very tight rope. The need for independent directors. So after going through the legal provisions, it is very important to understand what is the exact role that needs to be objectively exercised by the independent director. So to understand this better, let's draw a parallel from the episode of disrobing of Draupadi in the Mahabharata. So during the game of Chaucer or dice between the Pandavas and Kauravas, the Pandavas were cheated of their entire possessions, including themselves and Queen Draupadi. So, which led to ultimately the act of disrobing of Draupadi. The important point that needs to be considered is none of those present in the assembly hall could rise to the occasion and stop the wrong from being happened. Had anybody done that, the entire Kurukshetra would have never been could have been avoided. If we draw a parallel to this incident or this episode of Mahabharata to the corporate setup, the disrobing of Draupadi can be compared to the abuse of power by executive directors, and the independent director having the role of standing up to the occasion and also opposing the board or the management, wherein their decision is against the interest of the stakeholders, is what forms the integral part and the crux of being an independent director. Hence, the role of independent director is extremely important, not only for the company in general, but also for the corporate governance practices. With this, I come to the end of the presentation.
Thanks, Jasveen. Thanks a lot. Mr. Bala, will you take the questions quickly?
Dipti, Raja sir has raised his hand in between. I could see that. Raja sir, you may first take up your question.
Yeah, thank you, Sudhakar. Sudhakar, you spoke at the very beginning about the dangers of becoming an independent director, and that one should not take up independent directorship merely as a feather in one's cap, etc., etc. Now, if there is an option for a person to become a non-executive director, non-independent director, versus becoming an independent director, what would one prefer? What should one prefer?
Non-executive, non-independent director.
Yes, non-executive, non-independent director versus independent director. Which is the safer of the two? Which one would you?
The answer I have given to you: non-executive, non-independent director.
Acha, non-executive, non-independent director is safer.
Yes.
I agree with you. I agree with you. Okay, so, and a quick second question. Sudhakar, what is the logic behind ESOPs not being given to independent directors while they can be given to the non-executive directors?
Sir, it is the conflict of interest. See that why that stock options are not to be given. Both Companies Act as well as listing regulations both have prohibited that. The reason for that is that conflict of interest. The moment that independent directors come to know that they have going to have the stock options, and
yes,
it is a kind of thing which is not linked to the profits of the company as such. See, if it is a commission, it is linked to the profits of the company, whereas stock options is concerned, it is not linked to the profits of the company. It can be, it can be even sometimes it may not even be linked to the performance of that particular directors also.
It can be quite arbitrary. Yes.
Yes. So the promoters can always lure the independent directors by giving the stock options to keep them quiet. So that is the mindset of the regulator. And that is what my interpretation is.
It was introduced about 3-4 years ago, right?
Yes, sir. See, earlier what happened was actually, this was there, I think, if I'm not wrong, from 2017 onwards.
Yes.
Earlier, it was even given to the independent, the nominee directors.
That was stopped. LIC
that was also stopped because of that issue. If I'm
LIC
not
versus
LIC, I think LIC or something
LIC
like that.
and Larsen and Toubro, I think.
Yeah, Larsen and Toubro. Yes, there the independent director said that I am entitled for this, not my company. Yes. Whereas the company said that you are a director nominated by the the insurance corporation, insurance company. So it is the company which is entitled for, not
Yes,
you as an individual.
that was quite correct. That was quite correct.
Yeah.
Oh, thank you very much. Thank you.
Thank you, sir.
Okay, let us quickly go through the question. There is someone has put up a question, lead independent director recommended by the Kotak, but I am not mistaken, it is not accepted by SEBI.
Lead independent director, whether the question is, it is.
See, the answer to that is that, yes, no doubt about it, Kotak committee has recommended appointment of an independent director, but SEBI has not accepted it. It is not mandated today. But good companies do appoint lead independent director. In Reliance, if you see from 2005 onwards, we do have a lead independent director, and especially the lead independent director is not getting any extrajudicial powers as such. He is not like any other director only. Only thing is that in case of a lead independent director, you have to define what is his role. Primarily, his role is just to coordinate the issues of independent directors with the board or with the chairman as such, because every independent director cannot approach the chairman. That is not a correct way. So somebody can be the representative of the independent directors, and that is the lead independent director. Sometimes wherever the conflict of interest of the chairman or the MD comes, or CEO MD comes, and that point of time, the lead independent director can take that particular agenda item. He can act as the chairman, whether in the shareholders meeting or whether it is in the board meeting is concerned. The third thing is that lead independent director always takes the initiative of organizing the independent directors meetings and to decide the agenda, minutes, etc. things. This is precisely what is lead independent.
Many companies have actually gone for the lead independent director appointment voluntarily. They are doing it actually. You know, the company where I was, we had a lead independent director. Definition of the independent director defined in the LODR is this equally applicable to the debt listed, but equity is not listed in the company.
Yes, regulation
any company which is listed, whether debt or equity, it is a listed company. When you talk about the corporate governance now, it is applicable accordingly. Yeah.
Particularly to high value debt listed companies.
We have covered.
Yeah, 1 minute.
Take next.
Upon resignation of independent director, can his relative replace him and be appointed as a ID?
If he is qualified, yes.
I think it is the equal responsibility of the incumbent ID also vacate the independent. That is already is only putting a view. Independent director be new, neutral, unbiased has to mainly contribute. That's also his view, I think so. Can an independent director provide a service in a professional capacity? Will it amount to the pecuniary interest or will it affect the independency by any means?
See, it is in the 149(6), it is already given there. In case of a legal profession, it is up to the 10% of his receipts. It is permitted, but that is only permitted for the lawyers, not for other professionals. So one has to be very careful about that particular provision is concerned. In other cases, what happens is you have to see that 197(4) it gets triggered. And you have to, if it is in the ordinary course of business, arm's length, like related party transactions and all this, we have discussed earlier in our previous webinars.
In a listed company, ID have not passed the examination or registered with the data bank. What is the consequences? I think we discussed this. You said actually it is one of the prerequisites at the time of the appointment itself.
Correct.
Implication of the non-appointment of the independent director in the company within the prescribed time limits, penal provisions. Of course, if you don't comply with the thing, penal provision will automatically take place. You'll have to face. Yeah.
SEBI may go even suspension of trading of your shares also.
If a professional like CS, CA, CWA want to become a ID in any company without obtaining the DIN number, can he be also? If so, no. No. Without the DIN number, no appointment can take place.
Falling in the exemption. See that as a KMP, see that exemption rule says that as a KMP, if you are having 10 years of experience, you are exempted. So please remember that not as a company secretary 10 years experience and not as a CFO 10 years experience. It is as a KMP. That means only when you got appointed as a KMP, from their 10 years you have to count it, then only you are exempted, otherwise not. So, and this KMP appointment has come from 1st April 2014 onwards. So according to me, the KMPs whoever have been appointed, technically they are not completing the 10 years. Be careful about availing that exemption.
If we reappoint the ID by SR in the AGM, by special resolution before the AGM, before the completion of the first tenure, what would be the effective date, AGM date or the date of the completion? Because we are actually appointing the second term of the end of the tenure of the term, no? So it will be from the end of the tenure. It is not at the date of the AGM.
Yeah.
Yeah. Can an independent director during the cooling period of 3 years be appointed as ID in any other company in a group? Refer word indirectly in provisional section 149(11) of the Companies Act 149.
It is very clearly given 149(11). It says indirectly also it is covered. So you cannot have any pecuniary relationship, not only of that listed entity, but any other group company also.
The reappointment of the ID would require approval of the audit committee. You had said multiple times in the you discussed this elaborately. Audit committee approval, you elaborated this. I am 72 years. His appointment criteria is different.
If you are an executive director under the Companies Act, your appointment requires even a continuation, also a special resolution. As far as an independent director, once you cross 75 years, you require appointment by way of a special resolution.
Whether appointment of the independent director as additional director, this I think you discussed, I think so. Does it mean that the shareholder approval should also be in place before the term expires, and the LBR says shareholder approval within 3 months? Yeah, that also you think you elaborated this.
Elaborated, yeah.
Yeah. Proxy advisor, no, we don't want to take that. If a company is sold by the NCLT and in case of the filed against the directors and the key managerial personnel and present, what is the remedies available to the independent directors if CBI inquiry has been started? The director was appointed after all account becomes after NPAs.
Dipti, you are the right person to handle that IP resolved matter.
Even it is sold under NCLT, means you want to say that the company is acquired by new company.
Probably NCLT disposed of the case, the companies might have been acquired. That's what I think.
I am not getting the question. Basically, they are telling that in a company which acquired this insolvent company, independent director is appointed, and that person, and after appointment, CBI inquiry started. It depends on the inquiry. Simple logic is when the director is there and the event happened, whether that director when the inquiry is going on or not, will be responsible. This is a simple logic. Whether it is NCLT or anything, if that inquiry is for what, that we have to check. And if that independent director was present at that time, independent director, he will be responsible. Again, as regards the remedies to independent director, like normal remedy to independent director, it will be available. Just because it is NCLT or anything, it is no specific.
Requesting your use on a separate meeting of the independent director, whether company secretary need to attend such meeting. How about notice of that? You already discussed, I think, elaborately you talked about it. Can the board pay commission on the profits amount which can be different to each IDs and the overall limit fixed by the shareholders?
You can have different sitting fees for different independent directors also. I mean, sorry, the different commissions, not sitting fees.
Yeah, that can be done. It is at the discretion of the board, they can decide actually. Yes. Also, the IDs for remuneration for these IDs meeting seems to be conflict, hence the question. Is the IDs eligible for remuneration for this IDs meeting?
I have already answered that, under 197.5, Board can decide it. You can pay.
Any other meeting, you said actually,
Yes,
any
yes.
other meeting.
Yeah.
Okay. There is a guideline issued by the SEBI for evaluation criteria. Correct me if I'm wrong.
Yeah, madam has answered. Yes, there is guideline.
Okay. In most of the companies, independent directors are an indirect related to such case. How evaluation of the non-independent director can be said to be fair and transparent?
No, I don't agree with that. Independent directors are indirectly related and all. I don't agree with that because the determination of criteria, if you strictly comply with, indirect relationships also more or less got covered.
He is paying the.
Answered.
Yeah, he is paying the commission to independent director is a mandatory requirement.
Madam has answered no.
Okay.
But I have one question here. Maybe Sudhakar, you can say that independent directors' remuneration could be different. But do all the independent directors get percentage commission or say profit commission, or only few can get it and few don't get it?
Technically, madam, technically it is like this. Payment of commission to the independent directors is subject to the approval of shareholders. Shareholders may empower the board to decide about the commission of independent directors. Sometimes it may so happen some independent directors take very active part in advising the boards, and some directors are not able to do that. In such case, the board may determine the independent directors' commission slightly differently. That doesn't mean you will not give a commission to a segment of independent directors and the remaining you will give it to one segment only. That is not legally, there is no prohibition as such, but it is governance point of view, it is not correct. Even proxy advisory firms will take it in a negative way. Because that means what you are influencing some independent directors by paying them the extra commission, which is not correct governance point of view.
Correct. Yeah. Right.
Can you share some comments on what you felt or what you felt worked or not worked in the recent Byju's matter?
Then let us not talk that thing here.
What does not overboard define?
I couldn't understand the question. What is that?
What overboard?
What does not overboard define? I'm also not getting it.
I think they're referring to the slide says where the independent directors should avoid being appointed in multiple companies or too many companies that they're not able to dedicate time for the meetings or effective decision making.
Might be. Yeah.
In a case where an independent director is not for the proficiency test after being registered in the data bank, further they are actually restored for further 1 year in a separate category. So what is the legal status during that 1 year? He is in the data bank, but under the separate category, please elaborate.
He cannot be appointed as an independent director.
Okay. Somebody is given the important takeaways. Then some appreciation. Now again, the appreciation is coming. How could the objective be achieved by the independent director appointment and compensated by the shareholders and the board?
I
don't know what exactly is the question here actually. Can ID be held responsible by banks and financial institution of the companies as one of the bank was trying to form charge against the IDs? They approve the financial at the board meeting. Will it form a day-to-day activities of the company or borrowing of the ID would also be made involved for the same? General view would be appreciated.
See, it all depends, you cannot just hold the IDs responsible for everything, you have to see what exactly is the nature of the issue with the banks or financial institution. Then only we can say that you cannot just pass a general comment like this.
Correct, you are absolutely right, because just because he has signed or he is one of the signatories, the board approves the financial does not mean that he is actually held responsible. Whether what is actually connected, as you rightly say, unless we know the case, whether it has gone through the duly board process, you are the party or not party, etc., that will depend upon. So this we cannot answer generally. What are the examination fees to attend the proficiency examinations?
I think they can see the website. Let's go ahead.
Yeah. There are duplications of the evaluation process, nomination committee, independent directors, and board, etc., and other things and all.
Yes, to some extent, overlapping is there in the Act.
Okay. How CS can actually save himself when the appointment comes to know that ID are actually relative of the director, promoter, and they are not willing to appoint the new ID.
See, subsequently, if any new fact comes to the notice of the company secretary and that impacts the independence criteria of the independent director, then the management, the board is to be informed about that, and that gentleman has to resign from the independent directorship. However, the board may treat him as a non-executive, non-independent director. It is up to them to how they will deal with. But he cannot continue as an independent director.
In fact, in the beginning only you said actually the various criteria which are actually required to be fulfilled, formulating the sheet and asking the questions and ultimately arriving the thing. That's exercise which you already said the company secretary is to do. Not only that, you also said in every year it has to be checked and changed circumstances, in which case company secretary has to be vigilant. As you rightly say, if it is not there, then at the moment it comes to the notice, you have to act on it. A person can be ID in how many companies?
See, that as far as the listed companies are concerned, a person can be an independent director.
Sudhakar, we lost you.
Some audio problem.
Is it okay now?
Yeah.
Yeah.
So a director can be an independent director of 7 listed companies. And if he is a whole-time director, he can be a director of 3 listed companies as an independent director. If he is a whole-time director in any other company. And suppose if it is not listed companies, in case of unlisted public companies, he can be a director, as you know that 10 public companies, he can be a director. So he can be an independent director of 10 public companies. And he can be independent director of 10 private companies also.
I retired as a senior partner of accounting firm after serving in that role for 26 years. Am I a KMP?
Am I?
KMP, key managerial person.
It depends upon how diligent and how vigilant you are.
Can an ID after the expiry of the 2 years from the appointment as non-executive, non-independent director immediately on the expiry date as ID?
See, what the listing regulations say is once your term of expires as an independent director, there should be a cooling period of 1 year to get appointed as an executive director, right? But as a non-executive, non-independent director, you can be appointed from the next day onwards also, no problem. But
Mr.
Yeah, yes, Dipti.
Yeah.
Just Mr. Mahesh, I am allowing you to speak. Just hold for 1 minute. Once Mr. Sudhakar completes.
Yeah, I am okay. Yeah, let him go ahead.
Because in the starting only he asked the permission. Mr. Mahesh Mittal. He has asked the permission at the starting. Mr. Mahesh? He left or what?
Yes, ma'am, it seems that he's left.
Reappointment, the ID recommended of the NRC or audit committee?
Definitely NRC, depending upon the related party transaction, audit committee.
Yeah. A person can be ID in how many, that you answered. I think that's all. We have come to an end.
Thanks. Sorry, I was not able to give time to Mr. Mahesh. I thought last 2-3 minutes I'll give it to him. I'll request our guest to share some,
concluding remarks.
Or her experience, because there is a specific request by the participants also. So I'll request Doctor, please share some experience, please.
Yeah, thank you. I think, sharing and learning, they go hand in hand. So today's session was for me more of learning, or revising what I have learned. So that was, I think it was wonderful once again to go back through the notes. And I've heard Sudhakar at IOD and attended probably sessions also. So that was quite insightful. As far as my experiences are concerned, yes, they're not so technical, but they are more based on relationships, undercurrents of the board, and how promoters and CFOs or CXOs, non-family members, how they interact and what are the dynamics that happen. Maybe we could think about that another session somewhere where I can share. And women independent directors definitely is a topic which is hot. It's been discussed a lot. And I think at your end, Mehta and Mehta can think about that topic also for discussion purpose, because not that there are many women independent directors yet ready, and they do contribute to the boards, which we keep on being a woman independent director. I'm not saying, but I do also say, and I was talking to Professor Bala yesterday and said that it's men also on the in the board. They need to also learn few things when you have a woman working with you and sitting with you in the board position. So that's another topic, of course. But I think overall, participants, their enthusiasm and the questions that they asked, and I'm really very happy to see and learning and interacting with the sessions. And my best wishes to all of you, the organizers, to continue doing this excellent job of knowledge sharing and knowledge providing to the fraternity. Thank you.
Thank you, Dr.
My appreciation to Jasveen for the excellent presentation which she has made with the chart and other thing and all in a very, very explicit manner, and also very understandable, simple English communication. The flow was very good. Presentation was actually excellent, coupled with the case studies, etc. and all this thing. You have done a wonderful job, Jasveen.
Thank you so much, sir. Means a
Thank
lot.
you.
Over to Dipti.
Thank you, Mr. Sudhakar. Thank you, Doctor. Thank you, Jasveen. And I apologize to Mr. Mahesh that I was not able to give time, just for 2-3 minutes left, but I'll connect him separately and ensure that his point is communicated. Thanks a lot, everyone. And next Saturday with new topic. Thank you.
Thank you. Have a nice weekend.
Thank you, sir. Thank you.
Thank you. Bye-bye.